I'm so excited you're all here. I know a lot of you, and for those of you who I don't know, my name is Margaux Valenti. I am the chair of the Alumni Engagement Committee for the Alumni Association, and so we started these webinars as kind of a COVID thing / we live all over as a way to connect, and this is, oh, I don't know, our 5th or 6th one, and this one I'm super excited about. I'm like a high school teacher who gets like way too jazzed about things that aren't too exciting, because we had an idea, we threw that idea in the garbage, and we came up with a brand new idea, all at the bequest of the panelists, because we wanted to have something that was timely and lovely. So I will get into that in a hot second. But first, I wanted to just kind of let you know who's on the phone from the school. So we have Crystal Brownell, who is the Director of Alumni Relations, Lauren Close, who is the Communications Manager for the Alumni Office, and then Brooke Herndon, who is the VP of the Alumni Office. I might have got your title wrong. I apologize, Brooke. So they've been helping us behind the scenes get all these webinars off the ground, scheduled, those beautiful invitations that you get. So we are so thankful to having them here. As well as all of the alumni. There are 40 of us right now, and we have 4 speakers. So this is absolutely fantastic. A couple of housekeeping items. You will, at the end of this, get a survey. If you can just fill it out and let us know kind of what you thought, but also like what topics you want to see the webinars go through. If you want to host a webinar, really whatever is in your brain would be really helpful for us to get feedback as both the board and the alumni office. Also, if you can go and change your name on your little screen here, if you don't know how, the little 3 dots in the top right corner, and then just change it to, you know, your name and maybe your class. Like my name is too long, but it would be Margaux Valenti JD’13. And then I think that's about it. So we're going to keep everybody muted to avoid background noise. Questions. The panelists have decided that they will take questions throughout the panel, so you can put them in the chat, and I or Christopher Smith will pay attention to the chat and get those moderated. And I think that's really it. I'm so excited to see faces from all over. I should be in beautiful Buffalo, New York. Go Bills. There was no way you were getting through without me saying that. So on to the actual people who matter today. Our first speaker is going to be Natalie Wicklund. This panel was Nat's idea, really. And she is currently the pro se law clerk for the U.S. District Court for the District of Alaska. So I think she wins for being furthest away and in the hardest time zone. She will be followed up by Rachel Margulies Strecker, who is a senior associate at Barr, Sternberg, Moss, Silver, and Munson. She is still in Vermont. Christopher Smith, who is currently serving as the Associate General Counsel for the Massachusetts Cannabis Control Commission. And then last but not least, Adam Schmelkin, who is a senior staff attorney at the Family Defense Practice at Brooklyn Defender Services, also in New York, but that's the wrong New York, but we will let it slide for purposes of this panel. So with that, I will turn it over to Natalie to kick things off.
Oh, thanks, Margaux. So welcome. I have to say, I'm really touched. I see so many wonderful friends of mine from so many years past. Jessica Wilkerson, I'm talking about you, and I'm sorry we haven't talked in like 9 months. So it's really great to be here. And I just want to start off by saying that this wasn't the panel that I had planned for today. You know, before the holidays, the alumni office reached out and asked if I would talk about the 8th Amendment and prisoner civil rights, because that's really what I do for work now. I work with self-represented litigants at the district court, the federal court here in Alaska, trying to work on access to justice issues and prisoner civil rights cases. And then January 6th happened, and we had an insurrection against a branch of our federal government. And I think American history changed forever. I think the peaceful transition of power, which, you know, I remember talking about when I was a con law TA and trying to always kind of impress upon our students by taking a minute and saying, guys, this doesn't happen. We don't just give up power. We don't, not everywhere has free and fair elections like we do here. You know, it really shattered, I think, a lot of us. So in that being said, in a quick turnaround, I scrapped that panel. I'm hoping that we can get to it at another point in the year. So I did have some really great speakers lined up for that. But what we're going to talk about today is the Constitution. And so what we got here today is we actually have 4 generations of constitutional law TAs. Rachel was Christopher's TA, I was Adam's TA, and so we got 4 of us. We are not experts in the areas we're talking about today, but we love it. We love the topics, and we think that now more than ever, as we're witnessing and we're living these monumental pieces of history, our Constitution is being tested unlike it's never been tested before. And we are in new areas of law and of practice that it's important for us to be having these discussions as a community, as friends, as neighbors, and quite frankly, as lawyers. As lawyers, we are pillars in our community. We are looked to by our friends, our family, and our other members when things like this happen. So I hope the takeaways today or to help you feel more comfortable with maybe some of the topics that that are being talked about in the zeitgeist, and also just serve as a refresher, or in some cases, things that we never covered in class, right? I don't ever remember us teaching the 25th Amendment, but we're going to talk about that today. So just so as I'm going to give an overview who's going to talk about what. So I'm actually going to just kick it off first, and I'm going to talk about the First Amendment. We're specifically going to talk about the right to assembly, to petition, and to speech. Because in my opinion, when we're talking about the events around January 6th, we're talking about the transition of power in our current state. It actually begins and ends with speech, right? We had, years of conspiracy theories building. We had weeks of lawsuits that failed to meet basic pleading requirements. We've had social media, we've had news media, talking about, information, disinformation, misinformation. And then we had a 2-day rally in DC that eventually ended with people, leaving their permitted area. There was peaceable marching, and then we had an attack on the Capitol. Right? There's kind of no other way to parse that. So that's where I'm going to start from, because I think that's kind of a good starting point. Then I'm going to turn it over to Rachel. She's going to talk about Article 2 of the Constitution, which is executive powers, and she's going to talk also about the 25th Amendment, what that means, how that works, or how we think it might work. It's actually never been used before. And then Christopher is going to come in. He's going to talk about separations of power and impeachment. I can't think of a more timely topic. We just had a president be impeached for the 2nd time, and those articles of impeachment were transmitted to the Senate yesterday. So again, we are right in the mix of this. And then lastly, Adam's doing really great work on the fundamental due process rights of parents and the fundamental right to parent your own children. So I wanted to cap our panel today with something tangible about what the Constitution provides for us as citizens. And so I hope that is a lighter note that we can end on, that we can all kind of feel good about being attorneys, having sworn oaths to uphold the Constitution, and feeling protected by this document that has been enduring for so many centuries. So that being said, we'll have questions. I'm also just going to make a little caveat for myself. As an employee of the judiciary, I'm going to be refraining from any hot takes on any current topics. As you either went to law school with me or personally, like I am all hot takes, right? Like I am nothing but opinions. But since this is a public forum, it's being recorded, and I do work for the judiciary. In the event any of these items were to come up in front of a federal court, I have an ethical duty, obviously, to refrain from kind of being one way or the other on things. So please ask questions. If it gets a little bit too timely, I might decline your question. And I hope you understand that that's just for ethics, not because I'm trying to avoid you. Also, I may not know the answer, so it could be that too. So that being said, let's buckle up. I'm going to teach this just like we did con law, fast and furious. So I hope you guys are ready. First Amendment. Let's do this. First Amendment, here's the text. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. That's it. That's the long and the short of it. So that's 5 topics. We've got religion, speech, press, assembly, and petition. Why do we even have the First Amendment? Well, one, James Madison did a fantastic job lobbying and getting that Bill of Rights, our first 10 amendments, into our constitutional framework shortly after the adoption and the ratification of the Constitution to ensure individual rights. Specifically, the First Amendment's a reaction historically to the criminal sanctions that we used to see on speech and on the press in English society. It's also a reaction to the fact that in British and English society, there was a national religion. There was the Church of England, and there was many historical religious wars fought against Catholics and Protestants. And we can go on and on. I'm not Justice Scalia. We're not going to do anymore. So right there, there's the context for history. So today, as I mentioned earlier, we're going to talk about assembly, we're going to talk about speech, and we're going to talk about petition. So let's talk about assembly. Assembly is something that we really don't speak a lot about because quite often, and right now, the analysis gets wrapped up similar to the analysis of speech. But in light of January 6th, it starts with an assembly of people, right? And the right to assembly is the freedom to join others to express an idea. It is the only right that's not solely vested in the individual. It means that my right to assembly and Margaux's right to assembly and Melissa's right to assembly means that we all can get together as a group to express ourselves, to express our ideas. It actually means you can't just speak alone, you speak with others. There's power there. There's true power that's not guaranteed in many other countries. With this, it often involves nonverbal communication, right? It's the very mere existence of a group. We can be talking about a demonstration, a parade, a picket line. You know, it's more than just the words of the speakers. It's the je ne sais quoi, it's the placards, it's the number of bodies who are there. It's the mass engagement of people in expression. You know, we've seen the right to assembly as being critical to some of the most turning point or pivotal moments in American history, especially on the front of civil rights. The women's suffrage movement, you know, racial equality or the ongoing struggles thereof, right? We can think of, you know, this marches in Selma in 1968. We can think of the marches and the actions that we've seen this summer with Black Lives Matter. We can also look back to Vietnam and the anti-war demonstrations, or even more recently, anti-war demonstrations against actions abroad. So we know that the right to assembly is actually something incredibly functional in not even just our government, but ourselves as a people. One of the cases I do want to kind of point out in the right to assembly, and there just quite frankly aren't many in our case law, is from 1937. It's called DeJong v. Oregon. It was a per curiam decision. I see we got a couple non-lawyers. That means it was a unanimous decision. And that extended the right of assembly to the states via the 14th Amendment. So the right to assembly isn't simply just a federal issue. We have the right to assemble on everything, you know, and having states respect that. And the quote out of that case that I wanted to pull and just put out here was that the right to assembly is the right of peaceable assembly, is the right cognate to those of free speech and free press, and is equally fundamental. So that we don't think of assembly often, but it is just as important as the right to the press. It is right to our individual speech. You know, currently in the case law, assembly has largely merged into a speech analysis, which means that, you know, we may see time, place, and manner restrictions. We're going to talk about that in just a second, a little bit further. And really it breaks down into 2 functions. The right to assembly means you have the right to protest, and you have the right to association. In terms of the right to protest, and as we're talking about that time, place, manner, we have the public forum doctrine, which means the government may regulate activity in public spaces through, like I said, time, place, and manner restrictions, right? So we have permits. You may say, okay, you can all get together and assemble about this issue, but we're going to have you do it from like 8 to 9. We don't want assemblies after 10 p.m., there's a noise ordinance. We work inside of those restrictions to embrace our own fundamental rights. However, we want to be sure that, we can't deny permits based on content or viewpoint, right? Those are critical functions of the First Amendment that protect us. A very classic case that I think we all can remember is the Nazi march that happened in Skokie, where the permit was pulled based on content, based on viewpoint, because of the language. If that permit had been pulled because those Nazis wanted to march at 2 a.m, that would have been a permissible restriction. So with the second piece of assembly, we have the right to association. Again, and that's that core function of that. We have the right to gather in groups. We have the right for ideas and messages. And it's not just about public demonstration, but the ability to form membership and bonds. In that area, the analysis is a bit more murky. We haven't had a proper assembly case in about 30 years. The one that you may remember is Roberts v. United States JCs. US v. JCs, in that case, you had the National JCs organization, which was a civic, or continues to be a civic organization. At the time, they only admitted men for membership. The state of Minnesota had an anti-discrimination law, and those chapters in Minnesota started to begin to admit women. There was a conflict between the national org, the state of Minnesota, and the local organizations, and they went to court. And the question they presented in front of the Supreme Court was, did Minnesota's attempts to enforce the anti-discrimination law violate the JC's right to free association under the First Amendment? Was there a right to exclude? In the unanimous decision from the court, they held that the JCs lacked the distinctive characteristics that might afford constitutional protection to the decisions of its members to exclude women. And the court reasoned that making women full members would not impose any serious burdens on the male members' freedom of expression or association. So the court held that Minnesota's compelling interest in eradicating discrimination against women justified the enforcement of the state anti-discrimination law. So with that, we see that the Minnesota law wasn't aimed at the suppression of speech, and it didn't discriminate on the basis of viewpoint. And therefore, you had that assembly case. So that was the last major assembly case. It again focused on membership. And the more recent case that we see is Christian Legal Society v. Martinez. And that, I'm not even going to bother going into it, because essentially it takes expressive association and it merges it into a speech analysis. So with that, we're going to transition. So there's an overview of assembly, right? Membership, protest, association, assembly. With speech is an individual right. It is an individual right that only you carry, and it applies to really only to your own words. It's the freedom to speak your own mind. Speech is the big one that we think about under the First Amendment. And there's a lot of theories about why we even have it as a fundamental right. There's the function of how it affects our self-governance as a people and as a country. It is the discovery of truth. That's John Stuart Mill. Or, later we've talked about the marketplace of ideas, that being able to speak freely opens up those ideas. That it's in fact fundamental to personhood and to autonomy as people. And that speech can promote tolerance, because even unpopular or distasteful speech has a place in society. I'm just going to put a pin in that and say in our current times, I think that's a very interesting theory. And I wonder what our theorists would say in our current times. Our right to speech prevents governmental interference or reprisals from our speech, right? It does not apply to private citizens. Does not apply to companies. Right now, we're seeing a lot of deplatforming of, both political figures and of specific, speech content in light of the violence on the Capitol. But the First Amendment doesn't apply here. The First Amendment guarantees that the government lets you be free to speak, but it doesn't mean that you are free from the societal consequences of that speech. Therefore, for instance, if I were to say something out of turn on this panel, I could lose my job. Or, if I were to say something awful on Twitter, Twitter could feel free to give me the boot. All of that is perfectly legitimate under the First Amendment. So when we talk about speech, like what are we actually, what is that? What are we talking about? We are talking about talking, like I'm doing right now, writing, printing. There's also symbolic speech, right? We've seen this in some of our major Supreme Court cases. It could be a jacket that says, fuck the draft, like we saw litigated in Cohen v. California. It could be wearing armbands in protest of the Vietnam War, like we saw in Tinker v. Des Moines. It could also be something like burning crosses that we saw in Virginia v. Black. We may disagree with these areas of speech. We may find them very offensive, but they are in fact protected as functional speech. And as we just listed some of those aspects, speech is not unlimited, right? It is fundamental. It is protected, but it's not necessarily unlimited. There are restrictions. And we can see that generally speaking, it is very hard to have a content-based or viewpoint-based restriction on speech, right? Content-based would be limiting speech on its subject matter, whereas viewpoint is actually going to be limiting like the underlying view or the ideology. And for a government or our government to take action on either content or viewpoint-based speech, it must meet strict scrutiny. I hope we all remember strict scrutiny. I know I made my students sleepily chant it over and over and over again, but strict scrutiny is that the restriction must meet a compelling government interest using the least restrictive means, right? Strict scrutiny is the government is showing a compelling government interest using the least restrictive means. I hope that all is burned into your brains from here to eternity. Now, there are some exceptions, right? Obscenity, which is a little bit wonky. We're not going to talk about the Miller test today. If you're interested, Google obscenity in Miller and you will go down a rabbit hole, have fun. Child pornography is in my opinion, like the number one. That is content-based. We do not accept child pornography. It is criminal prima facie. If you have it, you are going to the clink. That's all there is to it. Not happening. There are two pieces of content-based speech restrictions that I do want to focus on today because I think they are very relevant. One of them would be called true threats, right? We saw this in Virginia v. Black, which was where the KKK the Ku Klux Klan was performing a cross burning. And the test that comes out of that case was whether the speaker means to communicate a serious expression of intent to commit an act of unlawful violence to a particular individual or group of individuals. And where a speaker directs a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death. The speaker, and this is the real linchpin here, the speaker must actually intend through the statement to instill fear. That's Virginia v. Black. We've seen the circuits, deviate and kind of have a few different tests in the subsequent years from that case, but that's the core, right? So that's true threats. If you are expressing true threats with the intent to instill fear of bodily harm or death, that speech is not protected. We also have seen a little bit of, I want to highlight just another case in that true threats doctrine, right? Which is Watts v. United States. This is a case from 1969. And the fact of that case was that we had a defendant who was arrested in an anti-war rally for the Vietnam War. And he was telling a crowd of demonstrators, if they ever make me carry a rifle, the first man I want to get in my sights is LBJ. And he was convicted under a federal statute that criminalized any threat to kill the president. We still have that statute. That's still on the books. And under the Watts case, they distilled 3 factors that I think, again, may be relevant in today's zeitgeist. The Watts factors were considered that the speech and the comments were made during a political debate. There was a conditional nature of the threat, and the reaction of the listeners in Watts was out of humor. The people in the crowd laughed, right? The people in the crowd had a reaction that was not one of fear, that was not one of violence. There was laughter. So in that case, in Watts, the court actually, threw out and reversed this man's criminal conviction and said that his speech was protected under the First Amendment. Since then, the true threats doctrine hasn't changed much, but I will just say that Justice Sotomayor, in two cases, one in 2015 and one in 2017, has urged the court to reevaluate and to clarify the true threats jurisprudence and to update it. Now, in both of those cases, they never reached the merits of and never even ended up in a speech analysis, so I'm not going to bother with them. But just so you know, we do have a justice on the Supreme Court who is interested in looking at these factors and kind of where we are now in terms of the bigger context of speech. So lastly, with speech, I do want to talk about the incitement of violence. The incitement of imminent lawless action is not protected under the First Amendment. And we have seen this in a line of doctrinal cases that go back, far, in the teens and in the 20s. Many of us will probably remember the clear and present danger test, right? I believe it was, we should have written this down. I want to say it's Harlan. It's not Justice Harlan, but it was one of those guys, one of our esteemed justices from that era, who said, you can't yell fire in a crowded theater, right? That is a clear and present danger. We're not going to permit that. That's not protected speech. That doctrine, that line of cases has extended, in the 50s and 60s, when there was a line of communist cases, as I call them. They were related to the Communist Party. And in Whitney v. California, a party member had spoken words, and I'm going to quote, are inimical to the public welfare, tending to incite crime, disturb the peace, or endanger the foundations of organized government and threaten its overthrow. And that speech, that context, had not been permitted. In Yates v. United States was another case involving members of the Communist Party. Said indoctrination of a group in preparation for future violent action, as well as extortion to immediate action by advocacy found to be directed to action of the accomplishment of forcible overthrow to violence as a rule of principle of action, and employing the language of incitement is not constitutionally protected when the group is of sufficient size and cohesiveness and are such as reasonably to justify apprehension that action will occur. That was wordy. Sorry, I should have edited that for you guys. That's what you get for cutting and pasting old case law. So that's the history. We start with clear and present danger. Then we start to see the court talking about, threats directly to the government. Size and nature of speech is really, on a case by case basis with them. The current case that I think is really the linchpin and our most up to date is Brandenburg v. Ohio, which I believe that most of us probably remember. It's one of those classic cases. And again, that was another Ku Klux Klan rally. Brandenburg was there. He was saying words that I will not repeat. And, really inciting and really ginning up the crowd. And at that rally, he announced a march, right? That was the issue. We had a lot of vitriolic speech, and then he announced a march. And he was arrested and charged. And under the court's analysis then, they were analyzing, was violence incited? And the test there is, was the crowd directed to inciting or producing imminent lawless action, or is likely to incite or produce such actions? So in Brandenburg, they decided, and I say they, the court, said this speech was protected because we actually didn't see imminent lawless action. We didn't have an outburst of violence. He was just announcing the march. He was ginning up the crowd, but we didn't actually have imminent action or violence. So that speech was protected. And later in Hesse v. Indiana, the court refined Brandenburg, and there they said speech must lead to imminent disorder. If the speech leads to imminent disorder, it is not protected. It is incitement to lawless action. And like I said, that is not protected speech under the First Amendment. So, again, the world of speech and under the First Amendment is vast. we have weeks, if not months, of material to cover. But in this short time frame, I did want to highlight those few items for you because I think they are the most important as we're moving forward and talking about the events of January 6th, the fallout from that, and how we move forward. How we talk about speech, how we talk about assembly is critical. We're talking about that all the time. So lastly, and my time is coming to a close, I do want to just touch on a very small part of the First Amendment. It shouldn't be small, but it is. We have the right to petition. We, as American citizens, have the freedom to present arguments to the government, and actually the right to petition is vast. It doesn't even just apply to citizens. Even historically, before there was women's suffrage, while we still have enslaved people in this country, the right and the freedom to petition extended to women slaves and aliens, to people who were foreign from this country. This was a long historical tradition found in the Magna Carta and even the English Bill of Rights. We can look at it as important to the Revolution. King George ignored the colonist petitions, and that is what drove the Revolution. And we ensconced it in our First Amendment. Today, our right to petition, I think we overlook it, right? It feels pro forma. We email a senator, we may not hear back. We write a letter, we may not hear back. We might make a phone call. We do hear back, but we get something on nice, shiny letterhead. But we still get to do that. The fact that we get to do that is ensconced as a First Amendment right, that we do have a voice in our government. Whether it's rulemaking in the environmental sector or whether it's, like I mentioned before, writing a letter to your congressman. So I hope, we've covered 3 things today. We've covered assembly, we've covered speech, a very, very limited part of speech, and we've covered the right to petition. I hope that as you move forward in your daily lives and as we are living this history, that gives you a little bit of context. And from there, I'm going to turn it over to Rachel. Rachel, you're up next.
Thanks, Nat. I'm excited to see where the jurisprudence goes on free speech as it relates to all of the pending, criminal charges that are being brought all over the country. So there's definitely going to be a development, and maybe we do an update like, a year or 2 from now. So I'm going to talk about the 25th Amendment and Article 2. And in getting ready for this seminar, I went back over all my old con law stuff and my old constitutional law book, and Cherminsky is going to be doing some updating because, man, they don't touch on any of this in the books, that we had. And we didn't really touch on it in our con law sessions because it didn't really seem all that important back then. And so briefly, I'll talk about the 25th Amendment first. And I just recently, since, January 6th and all of the comments about, the 25th Amendment, I went back before we even talked about doing this panel and actually read the 25th Amendment, and then stopped some people in the grocery store who were talking about why they should, why hasn't Pence invoked the 25th Amendment? And well, let's go through the 25th Amendment. So Section 1 of the 25th Amendment basically says if the president dies or resigns, the vice president becomes the president, right? Section 2 says when the vice president has a vacancy, that the president can nominate the vice president, and that with the majority approval of the House and Senate, that person will assume office, right? Section 3 says that when the president feels on their own accord that they are unable to discharge the powers and duties of the office of the presidency, that they may deliver to the president pro tem of the Senate, president pro tem of the Senate, and the Speaker of the House a letter indicating that they're unable to do that, and the vice president will assume the office. If there's going to be some sort of health procedure or something that would require them to, be incapacitated for a period of time. And then upon sending another letter, the president will resume their office. So those are all the ones that are not really relevant to this. It's Section 4 that really kind of matters. And that is the section that says with the vice president and a majority of either the cabinet or quote, such other bodies as Congress may by law provide, vote to remove the president from his duties, basically, or her duties, although it says his in the Constitution, so screw those originalists, right? But if the vice president and the majority of the cabinet, or I don't believe there's such other bodies as Congress may by law have provided for yet, they must transmit a letter to the Speaker of the House and the head of the Senate that declares that the president is unable to discharge their duties, and the vice president becomes the acting president. Keep reading the 25th Amendment. It says that when the president transmits to the Senate pro tem and the Speaker a written declaration that that inability no longer exists, they resume office. So in our scenario, had Mike Pence been able to gather enough of the cabinet to remove Trump from office, he would have only needed to submit in writing to the head of the Senate and the head of the House a declaration that he indeed is able to discharge his duties, which I think he would have done. And then the 25th Amendment goes on to say that the vice president and the majority can again vote within 4 days of the president having transmitted that letter to discharge the president from his office. Congress must then assemble within 48 hours, and within a 21-day period, they must decide by a 2/3 majority that the president is unable to discharge his duties. So practically speaking, the 25th Amendment would not in our situation have worked because it would have taken too long. I think Trump ultimately would have said he was fit, and even if they could have round two'd the consent of the cabinet holding the hearing within 21 days, he would have already have been out of office. So that brings us to Article 2, which talks a little bit, the relevant portions of which are the impeachment powers, but just a brief review of Article 2. That's where our president and the vice president get their power from. Section 1 gives them the president its 4-year term, requires the president to be a natural born citizen of the United States or a US citizen, be 35 years. They establish the electoral college there, payment for the job, and the literal oath of office is written into Section 1 of Article 2 for the presidency. So Section 2 makes the president commander-in-chief, gives treaty powers, pardon powers, not impeachment pardon powers, though. And there are definitely some, I think, outstanding questions about the validity and existence of potentially some pocket pardons. So that could be something that develops over time, whether those were given, if they're valid, when they are. Because part of the underlying thought on the pardons is the acceptance of responsibility for what you've done in a public setting. And so that wouldn't have occurred. And recess appointment powers are in Section 2. Section 3 of Article 2, requires the State of the Union. And it's Section 4 where we get the language that says the president, vice president, or other civil officers shall be removed from office on impeachment for conviction of treason, bribery, or other high crimes and misdemeanors. That language is the language that's kind of in hot debate right now because former President Trump is no longer president. And if we look, and I don't know if Chris will get into this, but if we go to Article 1, Section 3, Clause 6 of the Constitution, that's where we get the, Senate's power to try the impeachment. And the clause about whether judgment, extending for more than removal from office and the disqualification language, whether that applies or not, is quite literally a hot topic. About 6 minutes before we started here, the Senate voted by a 55-45 margin on a procedural measure that was raised by Rand Paul to say that holding the trial for the impeachment of a former president is an unconstitutional act. And so 5 Republican senators joined with the majority Democratic Party Mitt Romney, Ben Sass, Susan Collins, Lisa Murkowski, and Pat Toomey to say that it was appropriate. But there has been one time in history back in, I think, 1799, where the Senate found that they did not have the standing to hold the impeachment trial of somebody who had been impeached but was no longer holding office. So that didn't succeed yet, but that's an argument that has been made at the start and is anticipated to be made by the president's legal team, which, shows the weakness in the actual legal arguments they have to make. So there's not a whole lot of case law, like I said, in either of these areas. And I think a year or two or three from now, we will see a development of that. So maybe we do a redo of our con law after what happened as a result of the insurrection. So that's what I've got, and I will hand it over to Chris. It's really great to see all of these familiar names, and I hope everyone's doing really well all across the country. And I send well wishes from Vermont still. So if you're looking to come back, please feel free. I'm happy to house anybody, post-coronavirus.
Awesome. So as Rachel indicated, I'm going to continue us down this garden path of sort of removal and disqualification from office. And I'm going to do that sort of by looking at both impeachment and Section 3 of the 14th Amendment. So I'll start with impeachment just because I think that's something that people are more familiar with. And it's really, like, as Natalie pointed out, kind of the hot topic of the day. And so I'm going to, like Natalie said, come at you hot and fast with a lot of information. I recommend, I'm going to try to tell you what my sources are. So please, by all means, go double check them and check my work and analysis, because I am not an expert in any of this. But I did have a lot of fun doing this research. So I will share with you what I've learned. So some of this will be, a little bit of a review. But Article 1, Section 2 gives the House of Representatives the sole power to impeach. And Article 1, Section 3 gives the Senate the sole power to try all impeachments. The Supreme Court has sort of affirmed that in the case Nixon v. US in the early 90s, a district court judge tried to challenge the procedure the Senate used in order to impeach him. And the court said, nope, the Constitution is quite clear. This is a non-justiciable political question because the Constitution gives the Senate the sole power to try impeachments. So it is a constitutional commitment to a coordinate political government is the quote. So recognizing sort of that even right in Article 1, we're starting to see really a separation of powers play out with impeachment in sort of giving that sole power. If we continue on in Article 1, Section 3, Rachel alluded to the sort of limitation on the punishment that can be doled out for impeachment, saying that judgment in the cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. You see the Constitution is both carving out this political process, but also reserving the judicial process, because it continues on to say that but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment. So despite impeachment, the Article 3 branch still maintains its authority to bring people through the legal process. That also kind of clearly establishes a pseudo exemption, if you will, from double jeopardy, right? You can be impeached, but still then be subject to judicial penalties. Moving on to Article 2, Rachel also indicated that the president has the power to grant reprieves and pardons, but it is specifically carved out that the president cannot pardon from impeachment. So even the president's check on the judiciary sort of has a check on it when it comes to impeachment. Moving on to Article 2, Section 4, as Rachel indicated, kind of spells out that the president, vice president, civil officers can be removed for impeachment and conviction of treason, bribery, or other high crimes and misdemeanors. To Rachel's question about whether it's constitutional or not now that Trump is out of office, I would tend to think that that would be, if challenged, a non-justiciable political question based on the previous case law. But who knows, right? Maybe it's a new court and it's a different day, and so we get a different answer. I will note that high crimes and misdemeanors is not defined, and I think if in the past year we've seen a lot of buzz around what that means, and again, because so much deference is given to the Article 1 branch in terms of impeachment, it's really up to any given Congress to determine whether high crimes and misdemeanors has been met as a threshold. So moving on to Article 3, I just want to highlight just this tiny little piece that from a separation of powers perspective, I liked that Article 3, Section 2 says that the trial of all crimes, except in the cases of impeachment, shall be by jury. So again, really distinguishing between the judicial and legislative branches. So just to give a brief history of impeachment, I think most people think about impeachment in terms of presidents being impeached, but it doesn't only apply to the president. There have been 21 impeachments in US history. Most of them were actually of US district court judges. There were 8 convictions, 3 of which, so 8 convictions that removed the individual from office, 3 of which also included a disqualification to continue holding office. The case that actually Rachel referenced in 1799 was the impeachment of Senator Blount, who was impeached for conspiring to assist Great Britain's attempt to seize Spanish land. And so the Senate did decide that it did not have jurisdiction, essentially saying that senators are not subject to impeachment. So that's really interesting that was where they didn't have jurisdiction for that reason. But as Rachel indicated, the person never actually ended up being sacked. The Senate so-called sequestered the seat, not really letting William Blount take his seat, and therefore does not apply to the senator in that instance. In terms of presidents being impeached, the House has voted 4 times to impeach a president, starting with Andrew Johnson for violating the Tenure of Office Act. He was acquitted. William Jefferson Clinton for lying to a federal grand jury and obstruction of justice. He was acquitted. Donald J. Trump for abuse of power and obstruction of Congress. He was acquitted. And now again, Donald J. Trump for incitement of insurrection. That case is sort of now in the Senate. News reports indicate that it'll be picked up sometime in later February. So the question keeps coming up of, what is the penalty in an impeachment if Donald Trump is already out of office? Is there a penalty? And there does seem to be that tension between Article 2, Section 4, that just says the president, vice president can be removed from office for, treason, bribery, high crimes, and misdemeanors. But then Article 1, Section 3 says that impeachment can go so far as removal or disqualification. I question, could there be a legal challenge to whether or not the president can be disqualified from holding future office as a result of an impeachment conviction? Or would that be a non-justiciable political question? I think that's probably a novel legal question with that regard. Interestingly, what changes with the last time that Donald Trump was impeached, certainly the Senate composition has changed. So what that allows Democrats to do is have a little more control over the rules of the Senate trial compared with last time. But since a conviction requires a 2/3 vote of the Senate, there's no way, say, President Harris could really step in and be the game changer. What's interesting is, this is a little bit of a nerd wormhole that I'm going to take you down, but Article 1, Section 3 clearly says that there really will be no punishment for beyond removal or disqualification, but the former President's Act of 1958, which establishes retirement benefits for presidents, defines a former president as anyone whose term ended in any way other than a conviction and impeachment. So through that act, they've almost sort of tacked on an additional punishment that if you're removed by way of an impeachment trial, you would lose those retirement benefits. And so I keep wondering if there would be a legal challenge that could be made against the former President's Act of 1958 that it violates Article 1, Section 3, or again, would it be deemed a non-justiciable legal question? So I will just kind of stop there with in terms of impeachment. I kind of threw a lot at you, but I think impeachment right now is, it's happening, and it's happening again for the second time in 2 years. So it really is a relevant legal concept. And as Rachel indicated, we may really be seeing some jurisprudence developing around these concepts and really defining sort of these separation of powers of the political process of impeachment and how far Congress really can run with that without sort of violating other aspects of the Constitution. I'm going to jump really quick and cover the 14th Amendment, Section 3, which
we did get a question about that, though.
Yes, sorry.
If you didn't speak to this yet, the question is about Article 2, Section 4, the removed from office language. How does that apply, or what does it mean if the president is no longer holding office?
And I think that's a great question, because I think the answer is like, right? We don't know, and that's where the legal tension is really happening, because with respect to the Article 1, Section 3 talks about impeachments generally, but it does get into some detail about what happens when the president is impeached. For example, that the Chief Justice will preside over the Senate trial. And so the question is Article 2, Section 4, does that put a limit to the removal of the president? Is that as far as you can go as removal? Or is that to be read sort of with Article 1, Section 3 that lets it go a little bit further to include disqualification as well? And further, if it were, let's say this trial moves forward and President Trump is convicted with the penalty of disqualification for holding future office, and he sues, I think we'll get some really interesting either separation of powers jurisprudence out of that, or we will get some really refining of the parameters of what Congress can do in terms of their Article 1 powers. I hope that answered the question. If there aren't additional questions on impeachment, I will jump to the 14th Amendment, Section 3. I will note that this was nowhere on my radar until Natalie sent me an article like a week or two ago. So I've really delved into this, and I thought like, man, this will be a breeze by, because nobody's ever heard of this, right? But actually there is a surprising history here. So I'm not gonna read you Section 3 just because it is really wordy, but essentially what it breaks down to is anybody who ever took an oath to defend the Constitution of the United States and subsequently either incited insurrection or rebellion or gave aid or comfort to the enemies of the United States, that person would be disqualified from holding future office in the United States. If we look to Section 5 of the 14th Amendment, often referred to as the Enforcement Clause, it reads that Congress shall have the power to enforce by appropriate legislation the provisions of this article. So essentially, taking those two together, it does seem to read that Congress can name specific individuals or specific conduct that is disqualifying from holding future office, provided, of course, that it meets the requirements of Section 3, that someone had previously taken an oath to defend the Constitution and then violated that oath by insurrection, rebellion, or providing aid or comfort to enemies. But there's a little bit of a tension, and this is where we kind of break into two schools of thought around the 14th Amendment, Section 3. Because in Article 1, Section 9, Clause 3, there's the Bill of Attainder clause that says that no bill of attainder or ex post facto law shall be passed. So essentially it limits Congress's power to identify specific individuals, name them guilty of a crime, and apply a punishment to that, because that's clearly reserved in our separation of powers for the judiciary. So there are some who believe that Section 3 of the 14th Amendment is a clear exemption from the Bill of Attainder clause. And there are others who believe that you've really got to be able to imbue, if you will, other constitutional concepts onto Section 3, including the Bill of Attainder. And so looking through history in the United States, we actually have an example from both schools of thought that has never really been reconciled. Shortly after the 14th Amendment was ratified, there was a case out of Virginia where a defendant challenged his conviction, saying that the judge presiding was disqualified from being a judge. He had previously taken an oath as a member of the House of Delegates of Virginia, aided the Confederacy, and so therefore was automatically under Section 3 of the 14th disqualified from holding office. Chief Justice Chase, at the time writing circuit, wrote the opinion, essentially responding to that, saying, no, Section 3 is not a self-executing provision. Congress actually has to take the overt step of naming what this disqualifying behavior might be. And so, you know, the conviction was actually upheld, but interestingly enough, Chief Justice Chase went on in dicta to sort of say, here's how Congress should do this, and said that Congress should define the disqualifying behavior, but should really leave it to the judiciary to enforce. And I like his quote because he says, the constitutional amendments must be presumed to seek to confirm and improve rather than to weaken and impair the general spirit of the Constitution. So basically saying that these other concepts of no bills of attainder, due process, and separation of powers really has to be read into Section 3. But the other approach, where Section 3 is a clear exemption from the Bill of Attainder, was applied by Congress in 1919, when by a simple majority, it decided that Victor L. Berger had violated the Espionage Act of 1917 by consistently opposing World War I, and therefore was disqualified from holding Congress. So it really seems like, so there's been some chatter around the Capitol attack and whether or not Section 3 of the 14th could be used to disqualify, you know, state and federal officials who either participated or supported the attack from holding future office. And if Congress had the political appetite to do that, it would really kind of have to decide, does it want to follow sort of this dicta approach from Chief Justice Chase, or do you want to sort of take the Victor L. Berger approach where Congress sort of takes an exemption from the Bill of Attainder clause? You know, not that I really know, but I would think that either way, there's going to be some sort of litigation that unfolds, whether it's because, you know, Congress has given, you know, the ability to enforce a disqualification to the judiciary, and therefore there's prosecutorial discretion, and then all of the due process that comes along with being tried in those cases, or a challenge to whether or not Congress can name specific people and declare them guilty of certain behavior and therefore disqualified from running from office, which again would give us some really interesting jurisprudence around the separation of powers or really the limits of congressional power. I will note that Congress had taken, in 1870, had taken Chief Justice Chase's advice and had passed the first Ku Klux Klan Act, establishing that all of those who had previously taken an oath and then supported or participated in the Confederacy would be disqualified from holding office, but left it to federal prosecutors to enforce that. And they also made it a misdemeanor to knowingly violate the section, that provision of the Ku Klux Klan. So Congress has seemed to have taken both paths in the past. So it's unclear which path they should or would take now. But really interesting that I really didn't know that this Section 3 of the 14th really was a player in the mix, if you will. And it will be interesting to see if and how this unfolds moving forward based on you know, January 6th. So with that, I know I threw a lot at you. If there are any questions, I'm happy to answer, but otherwise, I'll hand it off to Adam to touch on due process.
Thanks, Christopher, and thanks everyone. It's really nice to see everyone and see names, see familiar faces. So I really like what Natalie was saying at the beginning about why we should end with due process. I think a lot of us felt understandably horrified and fearful after what happened on January 6th. And it's nice to reframe or reclaim conversations around the Constitution and constitutional law in terms of our rights. And I think even from a non-lawyer perspective, this is something that's accessible, like Natalie was saying. It's accessible to a lot of people. They understand that, while they may not know or understand case law or how the Supreme Court reasons and comes up with the decisions that it does, they understand that they have rights and that this document protects those rights. So I'm going to just start off by talking about the text of the Due Process Clause, and it actually appears twice in the Constitution. It appears in the Fifth Amendment and also the 14th Amendment. The language is close. For the Fifth Amendment, it says, "No person shall be deprived of life, liberty, or property without due process of law." And for the 14th Amendment, the language is, "No state shall deprive any person of life, liberty, or property without due process of law." So basically, in a nutshell, the Fifth Amendment is prohibiting government actions that would deprive a person of their life, liberty, or property at the federal level, whereas the 14th Amendment is prohibiting government action that would deprive a person of life, liberty, or property at the state or the local level. And I think in con law, most of our cases have to do with, I know rather, that the cases that we read in con law really have to do with the 14th Amendment, because the cases that we're reading about and the law around due process and fundamental rights is really shaped based on challenges to state and local actions. So the Due Process Clause affords three main protections. First is procedural due process in both civil and criminal proceedings. And then second, substantive due process, that's the protection of fundamental rights. And finally, the Due Process Clause also prohibits vague laws. I'm going to focus on procedural due process and substantive due process in a second. But the Due Process Clause also, there's a whole string of SCOTUS case laws that we study in con law about incorporation. Basically, the Due Process Clause is the vehicle by which the court incorporates the Bill of Rights as applying to the states. I'm not an expert on due process or on fundamental rights, but I'm certainly not an expert on incorporation, so we're not going to talk about that for purposes of this panel today. Natalie mentioned before that I work as a public defender in family court. So I work with parents who have either had their children removed from their care and custody or are at risk of having their children removed from their care. So there's an example from my work that I think really illustrates the difference between procedural due process and substantive due process. So when the government seeks to take away a person's life, liberty, or property, the government also has to provide adequate procedures. That's what we're talking about when we're talking about procedural due process. When we're talking about substantive due process, or excuse me, when the government infringes on an individual's right, on a fundamental right, it has to show that the action is sufficiently related to some sort of adequate justification, some sort of government goal. And that's what's referring to substantive due process. So one of the rights, and the rights that I practice every day, is a parent's right to the custody over their children. That is a fundamental right. So because parents have this fundamental right, if the government seeks to terminate or to end that relationship, to terminate a parent's custodial rights over their child, the government has to show that there's their purpose is, it's necessary to achieve a compelling purpose, right? The stated purpose in those kinds of cases, what we call termination of parental rights cases, the compelling state interest is the goal of achieving permanency for children, right? Taking children out of foster care so they're just not in the system forever. If the government is going to seek that kind of extreme action, which clearly interferes with that parent's fundamental right to the custody of their children, then the government has to provide, at a minimum, notice of their action and a hearing, an opportunity to be heard. Those are the adequate procedures before they can actually terminate custody and interfere with that right. So that's how procedural due process and substantive due process interact. So I wanted to start or talk about procedural due process in a little bit more specificity. Basically, procedural due process requires that whenever there's a risk of depriving a person of their, quote, life, liberty, or property, the government must, again, at a minimum, afford that person notice, an opportunity to be heard, and a decision made by a neutral decision maker. Liberty interest, courts have found, does include the loss of significant freedom of action, and property interests also include an individual's legitimate claims to entitlements or to government benefits. Procedural due process applies in civil hearings, so things like administrative hearings, right, the denial of public benefits, for example. Procedural due process applies in parole violation hearings and all the way up to full-blown criminal trials. So I want to just list some examples that stem from our own court system's principle of fundamental fairness. These are some examples of procedural due process assurances for individuals. I mentioned before an unbiased tribunal, right? The person or the decision maker over this hearing cannot actually be biased, but they also can't be seriously at risk of becoming biased. Notice of the proposed action and the grounds asserted for it. An opportunity to present reasons why the proposed action should not be taken. The right to present evidence, right? That includes the right to call witnesses on your own behalf. The right to know opposing evidence, right? To be able to attack that evidence. The right to cross-examine adverse witnesses. A decision based exclusively on the record of the evidence that's presented. The opportunity to be represented by counsel. The requirement that the tribunal prepare a record of the evidence that's presented, and a requirement that they prepare in writing findings of fact and the reasons that support the decision maker's decision. Again, that doesn't mean that all of these assurances apply in all kinds of hearings, but these are just some examples of procedural due process assurances. In 1976, the Supreme Court in Matthews v. Eldridge created a balancing test to determine the extent of fair process in these hearings. By creating this balancing test, the court's intention was to create a test that imposed procedural requirements in an expansive way, right? Basically meaning that the court recognized that the nature of different deprivations are going to require different kinds of procedural assurances. Right, you're not going to be entitled to the list of everything I just read above in all different kinds of hearings. So the three factors in the Matthews test are: 1, the importance of the private or individual right; 2, the risk of the erroneous deprivation of that interest through the procedures that are currently used by the government; and on the flip side of that, the value, if any, of affording additional or substituted procedural safeguards to the individual; and 3, the government's interest in fiscal and administrative efficiency, right? Maybe it would be too expensive or too time consuming to give all the kinds of procedural assurances that I was mentioning. That's kind of all I want to say about procedural due process. I think what most of us in con law have more fond memories of, what's a little bit more interesting, I think, is substantive due process, right? Fundamental rights. So when we're talking about fundamental rights, what are we really talking about? These are the rights that the court has found that some liberties are so important, quote, so deeply rooted in this nation's history and tradition that they have to be deemed fundamental rights, and that government actions that seek to infringe on those fundamental rights must meet strict scrutiny, like Natalie was mentioning before. And we're going to talk about those tests in a minute. So what are some examples of fundamental rights? Includes the right to marry, Loving v. Virginia, 1967. I just mentioned before the right to custody of one's child, Stanley v. Illinois, 1972. The right to keep the family together, basically the right to live among your extended family. That's in 1977, Moore v. City of East Cleveland. The right to control the upbringing of your child, Meyer v. Nebraska, 1923. The right to procreate, Buck v. Bell, 1927. Some really interesting and horrible history that that predates that case, history of forced sterilizations of disabled people and mentally ill people in our country. The right to refuse medical care, Crusan v. Director of Missouri Department of Health, that's from 1990. The right to privacy, so that extends, this I think is something that we definitely cover a lot in con law. It starts in 1965 with Griswold v. Connecticut, the right of married couples to purchase and use contraceptives. Of course, the right to secure an abortion, Roe v. Wade, 1973. the right to engage in private consensual gay sex, Lawrence v. Texas, 2003. Those are all different examples of fundamental rights to privacy. The right to interstate travel, that's another example of a fundamental right in Sains v. Roe, 1999. And also the right to vote, Kramer v. Union Free School District in 1969. The right to vote, when I was reading my Cherminsky, the right to vote, I think, was one of the few, if possibly the only fundamental right that appears in constitutional amendments. And the right to vote is mentioned in the 15th Amendment and, of course, the 19th Amendment.
Adam, we did get a question pop in, and since we're short on time, I thought maybe we could jump to it. So
let's do it.
Not to interrupt you, but Bo Morgan, class of 07, has a 5:30 meeting, but he raised the ever-present great question of, since DC is not a state, how does the 14th Amendment apply? And I suppose this goes for anyone on the panel, really.
I don't know the answer to that.
I have no idea either. So thank you for you guys.
Be that the protections afforded under the 5th Amendment to the people who live in DC as opposed to the 14th Amendment.
Yeah, I'm going to speak out of turn and agree with Rachel that I'm pretty sure that it's the 5th because of the federal jurisdiction functions there. So fingers crossed, it's the 5th is going to be my final answer.
That sounds right to me. I'm going to take it.
Sorry for interrupting you, Adam.
No, not at all. I think I was just starting to say that, you know, those that adopt that originalist perspective on the Constitution sometimes criticize fundamental rights, right? Because they're not, oftentimes besides that right to vote, they're not explicitly mentioned in the Constitution. So those that have that perspective, you know, sometimes they wince at upholding rights that are not enumerated in the Constitution, but some constitutional scholars discuss the 9th Amendment as one area to justify the existence of these rights that aren't explicitly mentioned in the Constitution. So the 9th Amendment does not give any rights. It doesn't empower any rights. And basically the plain language of it is, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So really consistent with this amendment is the idea that the Constitution protects all individual rights, not just the ones that are explicitly named in the Constitution. You know, I mentioned before Griswold v. Connecticut. Justice Douglas has some really interesting language in that opinion. He uses this metaphor of a penumbra. Basically, Justice Douglas, in justifying the existence of non-enumerated fundamental rights, he describes how, quote, specific guarantees in the Bill of Rights have penumbras. They're formed by emanations from those guarantees that help give them life and substance. Various constitutional guarantees create zones of privacy. So, you know, again, that was the case we were talking about before that upheld the right of a married couple to purchase and use contraceptives. And Justice Douglas basically is saying, hey, here are 3 examples in the Bill of Rights that give very clear rights to privacy, right? The 3rd Amendment is the ban on quartering soldiers in any house in times of peace. The 4th Amendment, of course, the ban against unreasonable searches and seizures. And the 5th Amendment, the protection against self-incrimination. That of these specific named constitutional amendments, they create shadows or penumbras of these zones of privacy, and that included within them, there has to be other rights to privacy. I mentioned before talking about the 2 different kinds of tests that apply in substantive due process. So strict scrutiny, like Natalie was saying before. If a government action infringes on a fundamental right, the government must show that the law is necessary to achieve a compelling government purpose. So the government would have to show, they bear the burden of showing that there's no lesser restrictive means for them to achieve their goal. If we're talking about a government action that infringes on a right that might not be a fundamental right, then the government only has to show that the law is reasonably related to achieving a legitimate government purpose. That's rational basis. So when we're dealing with a government infringement on a non-fundamental right, the government is free to pick from their options. They don't have to pick the least restrictive alternative. I want to just end by talking about the Due Process Clause versus the Equal Protection Clause. So the Equal Protection Clause states that no state shall deny any person within its jurisdiction the equal protection of the laws. So when we're talking about protecting fundamental rights, whether to make your claim under the Due Process Clause or under the Equal Protection Clause, we're really talking about how the arguments are phrased. So, for example, if a law denies a right to everyone, then due process is where it's most likely to be analyzed by the courts, right? The question before the court becomes whether the government's interference is justified by a sufficient purpose. On the other hand, if a law denies a right only to some, but allows that right to other, then the discrimination can be challenged as a violation of equal protection. So the question before the court becomes whether the government's discrimination to a certain class of people and who can exercise that right is justified by some sort of sufficient purpose, right? And again, strict scrutiny and rational basis, and also intermediate scrutiny would be another standard that the law, that the courts are looking at in assessing the constitutionality of those kinds of laws. So the court has upheld certain fundamental rights under just the Due Process Clause. So right, like the right to refuse medical care in Croissant in 1990, that one was just under the Due Process Clause. Other fundamental rights are upheld under just the Equal Protection Clause, the right to travel, Shapiro v. Thompson, 1969. Or sometimes the court has upheld certain fundamental rights under both the Due Process Clause and the Equal Protection Clause. So extending the right to marriage for same-sex couples in 2015, Obergefell v. Hodges, Justice Kennedy talks about, in his majority opinion, talks about this fundamental right existing and being protected by both due process and equal protection. So I'm gonna end there. If anyone has any questions for me about due process or fundamental rights, or I think we could, I'm the last panelist, so if anyone has any other questions about anything else that we've talked about today.
Yeah, so I know we're over, and I'm so thankful to everyone who did stay on. So if you have a question, I mean, you can use the chat function. We are all friends here. You can certainly just use your voice, because sometimes being a lawyer means you read all day and don't talk to other humans. So it might just be nice to like ask it out loud. So I don't see anything coming in, but by all means, just speak over me. But otherwise, I'll wrap it up, but still shoot out questions if you want, because I'm so thankful. We had 50 participants on this panel, which is just like warming my heart. 35 of you have stayed until almost 5:30. So this is just so lovely. I'm so excited at this community and this conversation, and I'm jazzed for all the people that got to see each other. Our next panel is going to be February 28th. And that is with Sharon Myers, who's JD class of 79. And she's going to look at teaching us how to enhance a host of competencies, including increased focus and concentration, your cognitive skills, your memory, and then ethical and rational decision making. So that one's really going to be a mental health focus next month. The registration's open. We're happy to have you all. And if you guys have further questions about this conversation or for the panelists, you can email the alumni email. You can probably find my email somewhere in the VLS archives, and we're happy to foster that conversation. So to the panelists, I'm so eternally grateful to all of you for throwing this together. If you guys want to add anything, please do. Otherwise, you are all free to go. Yes, Nat, of course.
Mark, I was just going to jump and say, I'm sorry, I told everybody 10 minutes. I think we all blew through past that. I hope you understand that, as a former con volunteer, I was so happy to see Adam Schmelkin just crushing. So it's been such a great panel. I love this community. I'm so happy to be getting more involved with it. And thank you for staying on. I really, I think our topics were really timely. And so I hope everyone took something from this. I know I really enjoyed putting it together, and I tortured Crystal for a hot minute. So I hope it all paid off at the end. Sorry, Crystal.
Not at all. You were fabulous. No, thank you so much for all of you putting this together. And again, you are a very, very timely topic, obviously. So thank you so much.
And not to be outdone, but per Nicholas Stiles, the real winner is Christopher Smith's brooch. So just had to put that on the radar. We had a whole talk about the brooch before we let you guys into this conversation.
Brooch. Love it. Love it.
Hope to see you all next month. But listen, this was awesome. Thank you for doing this so rapidly, such that it was a timely discussion. You guys are wonderful. Thank you.
Yeah,
Thank
great
you so
work.
much.
Good to see everybody. James.
All right, thanks for attending. Thank you.
That camera on.
Bye, everyone. Thanks so much.